Live from a grungy kitchen table located in Annapolis, Maryland's scenic and historic capital, it's the Maryland Crabs Podcast. With each episode, your hosts, Tim Hamilton, John Frenay, and the occasional guest will dive in and pick apart the stuff that really matters most to you. We're too lazy to actually solve any of these problems, but we can definitely stir the pot. From schools, politics, parking in the fire lane, to those horrible people who drive BMWs. And here with this week's episode, live from the kitchen table, Tim Hamilton and John Frenay.
Hello, this is John, and I am flying solo again this week. And if you are a regular reader of the Capital newspaper, likely in the past 5 years, you have seen periodic articles penned by former County Executive John Leopold. If you're a reader of the Capital, you probably also have seen the comments that follow those articles, pretty much encouraging the Capital not to print them and to, quote, just let him go away. Well, for 5 years he hasn't, and certainly in 2018 he's not, as he's running for delegate in District 31B to reclaim a seat in the General Assembly that he once held. We have heard about his campaigning for the past 2 years, but the only problem was we weren't quite sure exactly what he was campaigning for. Well, we asked, and he was coy at first, but now that the cat's out of the bag, the former delegate and former county executive agreed to sit down with us in his very first media interview since leaving office back in 2013. In our hour-long episode, we cover a lot of ground, from his history to his accomplishments in office, of course the trial and his resignation from his position as county executive for Arundel County, his sentence, and now his possible reemergence into the Maryland state political scene. What I learned with the time we spent together is that he's a very complex man. He has some innate desire to serve, as is evidenced by his resume. He made some terrible choices, which he freely admits, and for which I feel that he was very contrite. I like to think I'm a good judge of character, and I felt that this was very honest. A good part of our discussion centered on the trial and another horrible choice he seems to have made in his choice of attorney. His attorney is a mover and shaker in the Democratic Party. In fact, Bruce Marcus is the General Counsel for the Maryland Democratic Party. Remember now, Leopold is a Republican. Who hires the opposition's attorney? I poured over the trial transcripts, many newspaper articles from The Sun, The Post, The Capital, and my own coverage from Eye on Annapolis, pretty much to refresh my memory. Leopold also gave us access to his medical records, and in the end, his lawyer really didn't do him any favors. Based on the evidence that his attorney refused to submit, and the witnesses that he refused to cross-examine, and the contradictory testimony at the trial, I think John Leopold got screwed. There, I said it. Is John Leopold the right candidate to take back the 31B seat? Beats me. I can't vote for him. I live in 30A, but if I did live up in the Dina, I'd definitely be pressing the reset button on Leopold after learning this information. But again, that's not my job to do. That's up to the voters of District 31B. So sit back and listen in as I talk to John Leopold as he tries to become a phoenix, as he tries to resurrect a political career that many said was once in ashes.
I'm Sean O'Neill, your local RBC Wealth Management Advisor. When you choose to work with me, you'll have access to a worldwide network of financial products and services only available from a leading global institution. RBC's international reputation for physical strength and stability, world-class capabilities, and corporate values is unique in the financial services industry. I also recognize the importance of reinvesting in the communities in which we live and work, and I'm committed to serving my clients by building long-term relationships based on trust, integrity, and confidence. I look forward to helping you with your wealth management needs. Call me, Sean O'Neill, today at 410-573-6723 for a complimentary consultation.
RBC Wealth Management, a division of RBC Capital Markets, LLC. Member NYSE, FINRA, and SIPC.
We're here on the shores of Stony Creek in a spectacular view with a candidate for District 31B up here in the Dina, and a familiar name to many of us, and it's former county executive, former state delegate, John R. Leopold. How are you today?
Good. Thank you for asking.
Thank you for having us, and I'll get into why we're here, but just a little bit of a background about you. You were born in Philadelphia. You graduated college from Hamilton College, New York, right?
Upstate New York, Utica.
It was the House of Representatives for the state of Hawaii from 1970 to 1974, the Hawaii State Senate from 74 to 78, the Board of Education for Hawaii from 68 to 70, a unsuccessful gubernatorial candidate, which happens to half of the gubernatorial candidates, I guess, when you look at it. And when you returned over here to Maryland in 1983, you were elected to District 31, which was the House of Delegates.
82, took office in 83.
82 took office in 83.
Correct.
Served in there till 1990. It looked like in 1990 there was a little bit of a Democratic overthrow of this district, and they split the district as well into 2 districts. And you resumed office again from 95 to 206 in 31B, which is more the
31, actually. There was no B at that time.
Okay, it was still 31?
It's still 31 with 3 delegates.
Okay.
Today it's 2 districts, one a single-member district, 31A, and 31B, 2-member.
Is the 2 members. In 2006, in 2005, you were elected county executive for Arundel County.
2006.
2006, okay. And served until 2013 when you resigned after a trial that was everybody probably knows about. And now you are embroiled as a candidate for your old seat in a 2-member district going against current Representative Nick Kipke. Megan Simoner's seat, I guess, is the one that you're looking to take care. She is the existing woman, or the existing delegate. She's not going to be running again. And you've got Brian Chisholm and David Therian, that are running. So you've got 4 people running for 2 seats. And we had heard rumors a long time ago about, Leopold's going to run for something, but we just didn't know what it was. And now we obviously do. There was a letter in the Capitol about knocking on doors, and somebody was like, hey, how can he run again and everything else? And we had received a copy of a letter that you give out to people when they say, hey, I don't want to talk to you. That's not necessarily you. I know I was talking to John Astle. He said, NRA member, big game hunter, goes down to South County, and it's like, you a Democrat? Get off my yard. It didn't matter. So it's politics is a rough business. But essentially, you've got one thing that intrigued me. It starts off with a great quote at the top with President Ronald Reagan. It says, when you make a mistake, you take your knocks, you learn your lessons, and then you move on. And it's a campaign piece of literature that you give to prospective voters. And you reference a letter that you wrote to the Capitol 4 years ago about possibly running for something down the road. And you said you'd want to have the opportunity for anybody that was questioning your candidacy to have the ability to review your medical records as well as any relevant trial testimony that may not have been available during your trial from when you're exiting the county executive's office, and make their own judgment. And that offer still stands. So we asked. And to find out, because, one thing that you said too is in this letter, it says that if everything that was said about me during the testimony were true, I would not deserve to be a candidate for any public office.
That is correct.
So that's and again, you close it out with, and I'll put a link to this letter in the show notes on this, but I believe I'm entitled to seek a second chance from the people of my district who know my record of accomplishment and are willing to weigh in on my decades of service against my mistakes made during a time of debilitating pain. And it's a great letter. It really gives everybody just the opportunity. If I don't want to talk to you, I don't have to. If I do, I can give you a call. And you had given us some of the records that you referenced here. And a little bit of a background on this is you were serving as county executive, and it was during an election season where you were actually actively campaigning, and you had back surgery for two surgeries. Well, you had one in February. 2010. Mm-hmm. And then you had a second one in July of 2010 as well. And with any back surgery, I know my girlfriend's had one, and it's not the most pleasant thing in the world. It's very painful. You returned to work fairly quickly. You were discharged, I guess, a couple days or a week later out of the hospital. You returned to work first part of March, so you had maybe a week and a half or 2 weeks off after the surgery. And I'm assuming it was light duty and everything else. And trying to campaign, trying to run the county and everything else as well there. Where everything sort of happened, and your trial, just to sort of refresh folks, is that you were charged with
misconduct.
With misconduct in office, and also there was some other charges that were ultimately dropped through that. And then there was a private lawsuit that you were removed from, and then there was another one that was just sort of dismissed with the making dossiers on some other people as well. Throughout the trial, it was a very salacious 2-week trial, if I recall. There were all sorts of, there was rumors, there was innuendos. I mean, we had the stories about the cars in the parking lot at the mall, the bowling alley. And this is all the stuff that came out during the trial. Perhaps one of the more uncomfortable times I've ever had. I'm certainly not even compared to, what you had to go through. Just where I've looked at the things. I'd like to get in your words where we went wrong. What do we have wrong about John Leopold?
Well, if everything that was said about me in that case were true, as you indicated earlier, I would not be a candidate for any public office. I think it would be disqualifying. I don't think that anybody that was accused of cruel, abusive oppressive behavior should be a candidate for public office. But unfortunately, the truth about my case did not emerge during the trial. There was a situation where the issue regarding a catheter was discussed. And after the first surgery, let me back up. When I went into that first surgery, I was able to urinate. When I came out of the surgery, I was not able to urinate, so I was given a catheter.
And that's something that I did a little bit of Googling, and that's a fairly common thing with back surgery, with major back surgery.
In this case, what was extremely rare, though, is that you would lose, if you have spinal stenosis, what's extremely rare is that can cause what's called a neurogenic bladder, which means your bladder no longer works. That the pressure from those bones crushing the nerve eliminates your ability to have the bladder work properly.
Okay.
So that you need a catheter. In my case, barring some miracle, which I don't expect, I will have this catheter for the rest of my life. Now, what occurred was that after I went back to work, it was in the beginning part of March, I needed some assistance. Jane, who's with us today, read a statement during the sentencing part of my case in which she indicated that for 6 weeks, from about the second week in March until April 22nd, she assisted me by emptying a catheter bag. She would do that typically in the morning when I leave the house, and she'd do it when I came back in the evening. And I also had an assistant, a scheduling assistant, who had let me know, and other members of my staff, that she had a medical background and was willing to help me while I was in the office. What was alleged was that after April 22nd, and that's a very key date, on April 22nd, I was given what's called a catheter plug. It's about 1.5 inch plug, which fits at the end of the catheter, which means that I no longer needed assistance emptying a catheter bag. The catheter bag was located at my ankle, and because I could not physically reach it, I could not bend over, I required assistance for this 6-week period. It was alleged during my trial that after I was able to assist myself, I still asked for my assistant in the office to help me empty a catheter bag. Well, the key point is there was no catheter bag after April 22nd. So it would be impossible to require assistance if there was no bag that needed emptying.
To be assisted with. And for those that are listening that aren't familiar with a catheter, essentially it's a tube that ultimately goes into the bladder. It is sealed off. It can drain into a bag, which as you said, was strapped to your leg. And with a plug, and that has, I'm presuming, a little bit more capacity than the bladder. And with a plug, it essentially eliminates the bag. It plugs the end of essentially a hose, and whatever urine is in there is stored within the bladder until this plug is removed, and and you just relieve it. So this is a self-contained type of a thing at this point. I mean, there's no bend, and your reason you couldn't bend over was obviously because of your back surgery, right?
Correct.
Okay.
Correct. I was still in excruciating pain after the surgery.
Well, I know that you did send the records when I asked on the things and gave it to me, and I sort of had to laugh, and I'll paraphrase it, but your doctor, who is Dr. Biles, had said essentially that, you were squawking about the bag being visible when you sat down, and so that you would have to stand, and that in turn aggravated your back. So it was a real catch-22 type of a thing there. And that's on April 22nd. It showed, the medical record does show that through Arundel Urology over there on
Ridgely.
Yeah, West Annapolis, put a true flow catheter plug and told you instructions on how to use it, said make sure that you're, going to the bathroom every 2 hours and then use the bag at night. And subsequent follow-up visits essentially every month says pretty much the same thing. He's doing okay, doesn't use the bags, and he's using the plug. The only thing that's different was after your second surgery in July. Again, it was pretty much the same thing, except that they removed you off of morphine, I guess it was, for the pain for the back, which was not related to anything along those lines. But all the way through March 7th, when it showed that the plug and the prognosis and everything else was fine, and that's March 7th of 2011, from April 22nd shows, according to the medical records, the plug. So I do see your point in that it was, that it didn't exist.
Exactly. And Jane, my significant other, testified at sentencing that after April 22nd, she no longer had to help me because there was no catheter bag to empty. And I want to point out, during the trial, I had a driver whose name was Mark Walker. And during the trial, he testified.
I've got a little bit of his of the transcript from the trial there.
Okay.
And he talks about specifically remembering. He's questioned. Do you recall taking Mr. Leopold to Dr. Beal, which is Miss Thing, but who was the urologist on April 22nd? Yes, he does. And this is an officer with, I believe it's 29 years on the force, with 2 years in the executive protection with you. And do you recall there came a point in time after he went to Dr. Beal said that the need to have the catheter drained was no longer a problem? And again, he said yes.
It was no longer.
Suffice it to say that whatever it was that Dr. Beal, he took him to the Dr. Beal, and there was a change. You no longer were responsible for addressing the evacuation of the collection bag. Is that correct? And he said correct. And that's on October 22nd there.
I think that was January 23rd of. His testimony was during the trial on January 23rd. But yes, it was April 22nd when he was talking about not having to do it anymore because I had the plug.
Right. And then he does go on and says that, did you ever tell Mr. Leopold that, hey, dude, I don't want to do this? And he said, no, he didn't. And
nobody ever complained.
And then they questioned me even further, said, however unpleasant it may have been. And they said, yeah, I didn't say anything. And that's substantiated with Jane's statement that, as you said in the closing arguments, I've got a copy of that as well.
And let me make a point, too, about the medical records. On April 22nd, I was given the plug. But that record in and of itself is inconclusive. You can't just look at that record and make a judgment, in my opinion. But if you look at all the subsequent records in March in May and June and July and September and October, November, all those subsequent months where the medical record states that I no longer used bags.
The plug was in use.
The plug was in use always, no bags. And so here we have one of my drivers saying I didn't have to help him after April 22nd. Jane says in court she didn't need to help me after April 22nd. The medical records say that he didn't need help after April 22nd, and yet the testimony during the trial was that after April 22nd, I still requested assistance, which was false.
And it came through is that you were requesting assistance for months and months, up to 10 months.
Exactly, until January of 2011, when in fact the need for assistance ended in April 22nd, 2010.
So why wasn't this brought up at this point?
I asked my attorney at that time to cross-examine this witness, who I believe was the key witness in this case.
And she certainly was.
Absolutely. And I don't care whether it's 30 days or 30 years. Nobody should lose his or her freedom for something they didn't do. And in this case, I asked my lawyer, I said, you have to cross-examine this witness and present the true narrative. And his response was to me, I'll never forget it, he said, John, you have to stay focused on what's important. This is not a crime. So he never cross-examined the state's key witness.
But that was the crime that you were convicted of.
Correct. And let me just say this. It's very important to know this. This testimony colored the entire case. It gave the judge the moral authority to impose a harsh penalty. If I had been Judge Sweeney and I had heard this, I would have felt the same way. I would have thought, this guy is predatory, cruel, abusive, oppressive, and deserved a harsh treatment. So the judge never heard the truth in defense of my case.
But what did your attorney, and this was Bruce Marcus, what crime did he feel you were innocent of all crimes?
He thought I was innocent of everything. He said that was his major.
So going into this, he had the confidence that you were going to walk out of this and head back to 44 Calvert Street up on the 4th floor and
no crime, having committed no crime. Now, after all this occurred, let me back up in time. After the trial, I appealed this to the Court of Special Appeals.
Right. Well, your verdict was You were given a years in jail with
the sentence was 2 years in prison.
2 years in prison with
all suspended.
All but 60 days suspended.
All but 60 days, but 30
in the county
jail.
Locked county jail, and 30 with a home detention. 400 hours of community service, which is essentially 10 weeks of full-time working, and $100,000, I believe, was
it was an option. I could pay a $100,000 fine to the state or a $75,000 fine to the county if I worked out a payment plan with the county, which I did.
Okay.
And so I paid the $75,000 fine to the county. Interestingly, there's a state statute which says if you require an employee to campaign on government time, the maximum fine is $3,000. So even though the statute says the maximum fine is $3,000, if you call it something else, if you call it misconduct, the judge can levy a fine of whatever he wants. But I believe that this allegation of predatory, cruel, oppressive, abusive conduct colored the entire case, and it inflamed the court. It inflamed the trial judge, just as it inflamed the judges in the Court of Special Appeals later.
Well, it also inflamed the media and the public as well. I think that it's funny you just mentioned there's a statute about campaigning for a public official on a that is essentially one of the items that you were convicted on. But nobody talks about that.
No,
okay, we're talking about the white elephant.
And let me say this: that the charge was that I had these officers picking up campaign donations when I was flat on my back at the Arundel Center in pain.
Okay, now again, just for people that may not be familiar with how the county executive works and whatnot, you do have executive protection. Okay, this is not like you're rolling up to the 7-Eleven with a cop and a donut and saying, "Hey, I need you to go pick up my campaign signs. I'm the boss. Here's my ID," and go there. This is the I guess they're not detectives, maybe they are, but the police officers that are assigned for your executive protection as county executive, and their job entails moving you from place to place. They pick you up in the morning at your home. They take you to Arundel Center if you've got an appearance someplace, if you've got a fundraiser someplace, because obviously the protection is needed there. I know I questioned that when Janet Owens, your predecessor, was in there. Does somebody need that? And I questioned it again with Laura Newman, and she gave me specific examples as to why she felt she needed it. This is a police officer that is with you. That is, I don't want to say a friend because he's obviously an employee, he's a subordinate. But they're not rotating in the cop of the day for you, are they?
No, this is a specific officer who was with me for years, and you do develop a friendship with these officers. You do develop a.
Unfortunately, I get to. There's one in Annapolis that keeps always pulling me over. I keep telling him he's got to get me lunch next time.
But what I want to make a point is that the judge made the statement that what they did amounted to pervasive and extensive campaign work, which wasn't true. I mean, I had over 900 campaign contributions, and they may have picked up 5 or 6 donations and deposited them in the bank. They may have helped with a few signs. I thought they were doing this on the weekends or after 5 o'clock during the day for the most part as volunteers, compassionate volunteers wanted to help me.
And this was done because of your back injury.
Correct.
Okay,
Correct.
So I'm guessing you're saying that you would have certainly cruised out there and picked it up yourself.
In fact, every campaign for the last 50 years, I've always done my own signs. In this campaign that I'm running now, I've put up over 500 signs myself, personally.
Now here's a question for you. When you were county executive and campaigning for re-election, if you needed to pick up a check at, I think the Blue Dolphin was where one of them was picked up, if my memory serves, you would have an officer of your executive protection detail drive you out there, you would walk in and say, "Hey, Frank," or whoever it is.
If I was well enough, I would have gone and picked it up myself. I enjoyed getting the donations.
Do you, as county executive, did you drive yourself alone places, or did you use
sometimes? But during this period of time and during surgeries,
sure,
I was not physically able. I had a special couch brought into my office, and it was raised so that I could lie down easier every 15 or 20 minutes.
Okay.
And also in the van in which I rode, I would lie down in the back seat of the car.
Okay.
Sometimes when I was in that kind of pain.
Okay. So
but I just want to point out that whether it's one check or 100, it's wrong. I should have figured out some other way of getting somebody else to pick up a check. But the fact is that there were only I think 5 or 6 checks out of over 900. So it was less than 1% of the total contributions I received. It was wrong to have one check done that way, picked up that way and deposited, but it wasn't a big deal. It was just a minor thing.
Right. It's not like they come in and say, okay, well, we've transported him to the Arundel Center and now we need to go and collect his money and, or anything like that.
Yeah, it was very limited. And there were times when they helped me with a certain replacement of signs, most of that was done on the weekend or after 5 p.m. during the week when I thought it was being done by volunteers, and they offered, one of the drivers volunteered often to help me. Let me just say this about overtime. I found out, I didn't know these guys were on overtime and getting overtime at all. And then I found out they were getting overtime for doing the sign work, and that upset me because I'm trying to reduce spending in the county. And so I asked for an audit. I said, I want to know how many times they did this because I don't think this is right. And it's at that point that the person who was in charge of the overtime went to the state prosecutor and said, look into Leopold's activity.
Okay, so help me out here. In a campaign, you're running for re-election. You have executive protection, and you need to put up campaign signs. You've got a county car that's assigned to you. You go into your garage, you load up your red Leopold signs, and your driver would drive you around to the places that have given you permission to post the signs. And barring that your back was okay, you would get out of the car, you would put the little metal stake in the ground, put the sign on, thank the homeowner, and move on to the next one.
That's correct. And that was done in 97, 98% of the time, where I was present for that activity.
Okay. And the ones that they're talking about now are the ones where they've gone out on their own.
Correct. I frankly don't remember where they went, if they did, but I know that they acknowledged, one officer acknowledged, that most of that activity was done on the weekend when I thought it was being done by somebody who volunteered to help out of compassion.
Okay, so this is an officer that would show up at your garage or wherever to pick up your.
Well, I had the same car, and usually
right.
there were signs in the
trunk of the car. Okay, so he would have. Where does the car stay when you're on the weekend? Does it stay with the cop or with you?
No, it was with me.
Okay.
But occasionally they had their own car, and I guess they would get a few signs and put them up. I really don't remember where they did that.
Right.
But I do know when it was done, if it was done very rarely. It was not a major activity.
Sure.
It was a very small percentage because I enjoy putting up the signs myself, and I also feel very strongly that I do it myself because I know it's important to check with a homeowner, find out exactly where the sign should go. People are very particular where they want that sign to go on their lawn. And sometimes people will say, well, I don't remember giving you permission for that. Or okay, you can put up a sign, but I only want it there for a certain length of time. So it's a very personal activity.
And I will say that you have, and it's certainly well documented well before any of this came down, is that you've burned through a lot of shoe leather. You're the one that's out there knocking on the doors. You're more in tune with your constituents than a lot of politicians are. And it's always like, there was John Leopold out in South County holding the stupid red Leopold sign, waving to people in the morning. That you hear that all over the county. So it's not something that would be foreign to you to be there. I understand that.
But John, I want to make it clear that as I said earlier, that even if they only did this once or twice, I don't know how many times it was, but even if they did, it was wrong for me to allow that to happen. It shouldn't have happened.
And you called for an audit.
I did ask for an audit, but it's something I would not do again. But obviously, I'm not in the physical condition where I'd have to rely on anybody else to do it.
Well, obviously, everything sort of snowballed from the time that you called for an audit.
Oh, yes.
If all of a sudden they came back and they said, hey, these officers spent $10,000, whatever, what would have, had it not been snowballing where it was, would that campaign have written a check for $10,000 and to the county to reimburse them for that?
It's very possible that we could have done something like that. Absolutely.
Okay.
Absolutely. But again, it wasn't just the request for the audit of the overtime. It was also the binding arbitration legislation. It was at the same time that I asked for that audit where I introduced a bill to end binding arbitration for the police.
Okay.
And that caused a great deal of resentment. among the police. And even though...
So you've ticked off the 900
so,
cops in the county.
So at that time, I don't know if it's still true today, but at that time only Baltimore City and Anne Arundel had binding arbitration for the police. What that means is that an unelected arbitrator is going to decide whether or not there's going to be an enhancement for salary and benefits for the police. And I had no objection with an arbitrator submitting a recommendation to the county executive. The county executive would be bound to submit that to the county council, but I wanted to give the council the option of saying, hey, we don't want to increase taxes to have to pay for this. We don't think this is justified. I wanted to give them, as the final fiscal authority in the county, the option of saying, no, we can't afford to pay for this. That's all that the bill did.
And ultimately, I mean, you don't have the choice of accepting or declining that binding arbitration or the decision.
Now,
it goes to the council.
Yeah, well, that's true. But as I say, the law that existed before I introduced my bill, you had to fund the arbitrator's decision. And I don't think that that's the fiscally responsible approach. I think the council, as the fiscal authority, should have the option of saying we can't afford it. And I remember the Baltimore Sun at the time wrote a couple of very strong editorials in support of my legislation.
Okay. I want to step back a little bit onto the sentencing there. You were also barred, which sort of leads us into where we are today, but from, I believe it was ever running for candidacy, wasn't it initially? Or did they try that?
The practical result of that would have been barred for ever running because it said that I could not run during my probation, which was 5 years.
Okay.
But the legislature moved up the date to file for candidacy to February. It had been September.
Okay.
In fact, the House position was you could file. I think it was in April, but the Senate position prevailed in conference, and so the bottom line was that you had to file your candidacy in February. If that had been, in other words, if the prohibition on running had not been overturned, I would have been prohibited from running this year.
Right.
Because I would have not made the filing deadline.
Until 2022.
Yes, exactly.
Okay.
So as a practical matter, I probably wouldn't be running in 2022 for any office. So. Right.
Okay, and that was overturned on appeal, correct?
Correct.
That was pulled out of that, and the judge felt that was something that
the Court of Special Appeals.
Right. The panel of judges decided that was not there. They did not overturn the lower court's ruling on the misconduct in office.
No. But again, based on not having the factual information which they needed.
Well, it is. You sit there and you look at what's coming out here. I mean, you hear the salacious details, and that's what everybody is remembering. We don't remember that it was a cop picking up a check or writing a knockdown sign or something like that maybe cost the taxpayers $20 while in that afternoon when he did two signs or whatever it may be. How are you dealing with that on the campaign trail? I mean, when people, are you hearing people?
Well, the thing that people, most of the people who have an objection is because of the catheter issue. Mm-hmm.
And let me just say, as I read through all of the documents that I have read and refresh my mind on this, you've got the star witness that was your scheduling secretary, yet the non-human star witness was the Folgers coffee can or Maxwell House or whatever it was. And I just thought that was just sort of a red herring, even at the time, because, I mean, it's like, what are you going to do? I mean, it has to happen. And that was something that Jane had mentioned in her closing, in the sentencing statement, is that it's not pleasant, but it's something that you have to do. And
you want to stay
people
alive.
have the opportunity to say, okay, yes, I'm going to help you. Or, I just can't do that. Maybe I'm going to vomit. I just can't do that. Let me find somebody that can help you. Or, Mr. Leopold, hire a nurse. Whatever it would be, that would be, it's got to drain someplace.
But again, the key fact here, and the reason you and I are sitting down and talking, is because of the Court of Special Appeals and the trial judge never heard that after April 22nd, there was no need to request assistance because there were no catheter bags to be emptied.
I know the testimony also showed that you'd work part-time. You would go home at lunch and call it a day as well. So, I mean, we're looking, February 23rd to April 22nd. So, and
I didn't go back to work until the second week in March.
Right. Right. So we're looking
and even in that first week back, as Jane reminded me, it was a half a day.
So we've got six weeks,
really
one
5.
of which is half a days. Doing the math at every, on the medical records say, about every 2 hours or something like that. So, I mean, there may be
probably more.
Maybe 3 or 4 times a day during a working hour.
And it wasn't that often because I wouldn't do it just 2. I'd usually go longer than that. Usually go 3 or 4. The unfortunate thing is that that this key witness was never cross-examined because one of the key facts was that she informed me and other members of my staff that she had a medical background. That's the only reason that I asked her for assistance. I felt comfortable asking her for assistance. And she was the only one on my staff, my office staff, that I asked for assistance because she's the only one who told me she had a medical background.
Well, it's very interesting. You said that, you asked your attorney to let's clear this. Let's cross-examine her. Because if you we take the 30 days out, which was, I think, 15, I think it was, because you had the good behavior or whatever. How many?
No. In fact, in this case, the judge said even though I think 99% of the people who are incarcerated get a good time off, he insisted that I through the full 30 days, so that the home detention was only 12 days.
Okay.
They took the good time behavior off
of the home detention.
Of the home detention.
But one of the things that's interesting is that you asked your attorney to address this, because if you take all the sentencing BS and everything else that's out of here, when you come out of this, you're $75,000 poorer. You're a little bit more ragged because you spent 10 weeks, doing community service, unpaid community service. But it's this.
By the way, I'm on the board of directors of the food bank today, where I worked as my community service.
Hey, promotion from within.
There you go. And I was a big supporter of the food bank when I was county executive.
Yeah, food bank does wonderful work, but
anyway.
But again, you've got. It blows my mind that you're the client. I mean, you're the customer for the attorney. Now, you paid for your legal fees, right?
I did.
This was
not
not
my own pocket.
This was not the county writing
Nope.
writing a check here.
Correct.
And I've got this article from the Baltimore Sun back in 2017. Daniel Suleiman wrote. I mean, he's talking about a murder case and whatnot. He basically says that once a lawyer stops advocating on behalf of the client, he's now an adversary, and that's. I mean, what on the surface here, it looks like you got screwed.
Amen. I asked my lawyer 5 times after the trial and before the Court of Special Appeals hearing to please bring up the fact that the significance of that April 22nd date, that I no longer needed assistance because the predatory, cruel, oppressive characterization was false. It was based on a falsehood.
But it was still in the record, and it was still in the transcript.
And you could see if you look at the transcript of the the Court of Special Appeals hearing, you see where they were saying, just like with Franklin Delano Roosevelt, he needed assistance from his staff when he was in a wheelchair.
Right.
And that they made that analogy and say that Mr. Leopold truly had a medical need for that time until April 22nd. But if he still asked for assistance when he no longer needed assistance after that date, that would be unconscionable. That would be an abuse of his position, oppressive and predatory and cruel.
And it wasn't.
And it wasn't, because it never happened. Because after that date, there was no need for assistance because there were no catheter bags to empty.
Well, why does your attorney felt that was not we're going to get you off. There's no crime that's been committed or everything else. Okay, at this point, back in, and I'm drawing a blank on the date when you were found guilty. That was back in January of 13.
Yeah.
He's walking out of the courthouse going, well, man, I misjudged that.
But I'm the one who had to bear the consequences.
Well, absolutely. But I mean, Bruce Marcus has to be saying, wow, man, we were way off base here. Why didn't he correct that going into the court of appeals?
In fact, he offered to take my case on appeal to the Court of Special Appeals pro bono, which, and I thought to myself, well, here he is. He recognizes that he may have made a mistake during the trial, and he wants to correct that in the Court of Special Appeals. But he goes into the Court of Special Appeals and he says during that hearing, he doesn't correct it, first of all, but he also goes as well, when she decided that she didn't want to do it anymore, that's when it stopped. Mr. Leopold said, okay. And in other words, he not only didn't provide the evidence which was available to him to clear the record, he bought the narrative. He's supporting the false narrative of the prosecution by saying it stopped when she asked me to stop it, when that wasn't true.
It wasn't her. I mean, it could have been her decision to stop it at any point, but it was not her decision medically when to stop it.
After April 22nd.
After April 22nd.
There were no bags to empty. I walked into my urologist's office month after month without a catheter bag. I left without a catheter bag. I came home without a catheter bag. I left home without a catheter bag in the morning. There were no catheter bags after April 22nd.
What was
Well, I asked a number of attorneys after the case was over. I said, what are your thoughts about this? And they said every single one of them said they would have cross-examined the scheduler, that she was the key witness and she should have been cross-examined.
Well, certainly.
And let me say this, that in July or June and July of 2015, I did retain legal counsel, a lawyer named Tom Donnelly from Baltimore. And I asked him to review the case. And I wanted to find out if there were meritorious issues, if I had a case to bring based on misrepresentation by my attorney. And he said to me, I'm going to research this case. I'm going to look at the transcript. I'm going to look at all the information. And I'll tell you, I'll give you my best judgment. It may not be what you want to hear, but I'm going to give you an honest answer as to whether or not I think you have a case to appeal this conviction based on misrepresentation by your attorney. And his conclusion was that I had a very good case based on misrepresentation by my attorney. He said that I'm quoting my attorney, Tom Donnelly, said, his misunderstanding of the law prejudiced you severely in this case. By not cross-examining this witness and providing the evidence that was available, her testimony inflamed the trial judge, inflamed the judges on the Court of Special Appeals. If you read the transcript of the Court of Special Appeals, you see where these judges are saying, up to April 22nd, we can see a medical necessity for what Mr. Leopold did. But after that date, if he could help himself and he still requested assistance, then he's predatory, cruel, oppressive, and abusive. And if I had done that, I would have agreed with that assessment. I would never be a candidate for public office, any public office.
You probably sentenced yourself to a little bit more time.
But the fact is, it never happened because there were no catheter bags to empty.
When your attorney spoke with or cross-examined your executive detail, okay, that was another one of the, I don't want to say a star witness, but that was another one of the witnesses on this whole misconduct in office. Did he give any reason as to why he didn't want to talk to your scheduler?
Yes. His exact words to me were, quote, John,
it's not a crime.
You have to stay focused on what's important. This is not a crime, end quote. That's exactly what he said.
So he felt that the crime, if it existed, was the officers doing some campaign work.
He didn't think what they did was a crime either.
But why would he cross-examine the police officers and not the other person? That doesn't make sense to me. I mean,
that's a good question.
If this is not a crime and this is not a crime, why am I cherry picking to talk to this guy and not this person?
That's an excellent question, because she was the key witness in this case. As I said, her testimony colored the entire case. If you're a judge and you hear about this predatory, cruel behavior, you don't want to give any leeway to any of the other testimony. You've already made your thought. In fact, he already put the wheels in place for my incarceration before the sentencing hearing.
How's that?
He already had contacted the county jail and said, if I want to put Mr. Leopold in jail, you ready to take him? He already had put the wheels in motion for my incarceration before he heard the sentencing hearing. And my lawyer...
But his sentencing memorandum, or I don't know the legal term of it, was very long. And I mean, it was a long diatribe.
No, it had been substantially written before the sentencing hearing. My lawyer, Tom Donnelly, talked about that.
So there's a smoke. I mean, if you had a smoking gun that could have turned this whole case upside down at sentencing, that judge wouldn't have been able to hear it. Well, I guess he would have been able to hear it, but I mean, his decision was already made.
I think his decision was essentially already Tom Donnelly said his decision was substantially already written before he heard Jane's testimony. If he had given the true weight that he should have given Jane's statement basically rebutted. She provided the rebuttal evidence that was not provided during the trial. Okay, so if he had heard that, remember now, he did hear Mark Walker's testimony during the trial, where he said, after April 22nd, I no longer had to have
a system with changing the bag, and I knew that he no longer needed the bag.
So the trial judge already had that evidence. If he hears Jane's statement at sentencing, which is basically consistent with what Mr. Mark Walker had said, and he also had read all the medical records, then he would have had, in my opinion, at minimum, a reasonable doubt.
To sit there and say, well, why does A plus B not, why is this so different? Why is April 22nd versus November or whatever the date was that was alleged?
Yeah, she said 9 or 10 months, which means December of 2010 or January 2011. And so she's saying all that time she had to assist me when she never had to assist me at all because there was no catheter bag to empty.
Obviously not a great move on your attorney's part. I mean, and do you regret not taking the stand in your own trial?
Well, first of all, I would have gone back in time. I was offered a plea offer, which was a probation before judgment. In other words, no conviction if I had agreed to plead guilty to count one. Okay. In other words, count three wasn't even part of the case. If I had known,
and that would have been a 20-minute court case with a signature, and after probation it goes away.
Yeah, and there'd been no conviction. And so if I had known then what was going to transpire during the trial and in the Court of Special Appeals, of course I would have. Yeah. I may have taken the plea, but I thought, and I still believe today, yes, should they have picked up a single campaign donation? Should they have made a single deposit of a campaign donation? No. But does it rise to the level where I should lose my office because of that? I don't think so. I
agree with you. I mean, again, to use the analogy I did before, I mean, it's not like you rolled up to a 7-Eleven for a cop on a break and said, hey, here's a check, run this down to the M&T bank and put it in. This is the people that are with you. I mean, they're not terribly out of their way or out of the realm of what they do. And again, let's be real. Some of the executive protection does involve personal stuff. They shuttle you to the doctor's appointment. They shuttle you to, if you had some children, to going to their recital at whatever school it might be. Yeah, this is part of the deal. One of the
things that was unfortunate was there were no rules or guidelines for the detail. None.
And That's right. I do remember after the trial that was something that was.
And in fact, the trial judge said if there had been rules and regulations, this wouldn't have happened. He doesn't think this case would have happened.
Right, and I know that there are now as well. So very interesting. Well, how is it going on the campaign trail? How are you finding?
Here I find several groups of different people. There are people, and I think
I saw a lot of John Leopold signs coming in here. I got to say.
All right, the first group of people says, like I was just talking to a man earlier today, and he said I was talking about you with some friends of mine. I said, well, what's the reaction? He says they all know you did a great job as county executive. All right, so there's a group of people that know what I've accomplished. And I've done a lot for Pasadena.
I want to interject here a little bit. I talked to a former county councilman a long time ago about you. And I said, and I think it was actually even before the whole trial or anything like that. I said, what's the deal with Leopold?
Oh, you told me this.
Yeah. And he's like, great county executive, really, really on the ball. One of the weirdest guys I know. And it was like, I'm like, okay, well, that's, I'll take that. If I can get that as the worst, somebody can come against me, I think I'll call that a win.
Well, but I'm very independent. I stand up to the establishment politicians. I have my entire career. So I'm very independent. But anyway, you asked the question about where do things stand. Most people know the accomplishments I've made in Pasadena, which are considerable. boat ramp, fishing pier, police station, fire station, field for kids with disabilities at Lake Waterford Park. The list goes on and on. So most people are aware of that. There are those who say, I didn't have a good feeling about that case because I thought it was bullshit. I thought it was a railroad job. They don't know the details, but the intuitive sense is that it didn't smell right.
Didn't pass the sniff test.
Didn't smell the smell test. And so there's that group. And then there's a group of people who say, I don't want to talk to you. I didn't like what...
I know your name.
I don't want to talk to you. Please go away. And so it's those people, some of those people that I'm sending that letter to, because I believe if those people knew the truth, it would make a difference. And that
may not turn them around, but it would certainly give them pause for...
But it's important for me, even if I were not running for office, it's important for me to know that, for people to know that I'm not the cruel, predatory, oppressive, abusive person that was falsely described in the court. I want those 3 judges who sat on the Court of Special Appeals to know the truth that they never heard in the courtroom.
Right.
I want them to know because they wrestled with the whole issue of this turning point. My lawyer's position was whether you asked for assistance once or 100 times, it wasn't a crime. But what he failed to grasp was the gravity of the April 22nd date. What happened after that? And yes,
that's where the to me the misconduct and the abuse of your position
absolutely
comes in after April 22nd.
Exactly. But if you just look at the April 22nd report, that's not conclusive. But if you look at all the months report, the 7 or 8 reports after that, you see a pattern. You see that I every time I had a plug and no bag. So I don't know whether my attorney read all those reports or not.
Well, I know even on August 2nd, which was the first one after after your second surgery, it was your doctor's appointment on there. I mean, again, you would think that maybe there might have been a relapse after your second surgery. But I mean, again, it says there a patient continues to use the plug.
August 2nd, right.
And this
or June 28th too. Or that's right.
Yeah, I'm just saying that.
Yeah. I wrote it down. April 22nd is when I got the plug. The key medical reports are May 17th, 2010, June 28th, 2010, August 2nd, 2010, September 1st, 2010, November 9th, 2010, December 13th, 2010. All these reports say there were no bags, and yet the testimony from my scheduler was I had to empty the bags all that time.
And again, without any kind of medical background, I might make the assumption with the second surgery in July that there may have been a relapse or maybe have a need for a bag. But again, that August 2nd report says that, we're still using the plug as opposed to a bag. So, I mean, it's very clear with those 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 reports that beyond that, there was no bag. And it's substantiated by the detective's testimony or the police officer's testimony and the closing arguments from,
The point is that the Jane statement, Mark Walker's testimony are consistent with the medical records. My scheduler's testimony is clearly inconsistent with the medical records.
Right. And therein, it appears that you got screwed.
You got it.
You're running against 3 other gentlemen. Nick Kipke, I think, has done a very good job for the area. I know I've seen some signs that you've got Kipke, Chisholm, and I guess Nathan Volke is the county councilman for up here. And there's a 4th name on the sign I can't remember. But
Simon Ayer.
That's right, for state senate. And, so you're not the establishment candidate. You've said that you are not the establishment candidate. You never have been the establishment.
But it's ironic because I've been elected a delegate to 8 Republican national conventions. I've been selected by the Maryland delegation and the Hawaii delegation to serve on the platform committee at 2 conventions. And in the year 2000, I was named the outstanding Republican legislator in the United States. So I'm very independent, which can ruffle feathers at some times because I don't I'm not a lockstep rubber stamp for any other official. But yet I've proven that I can build coalitions with people on both sides of the aisle and solve problems, and that's what I think most people want.
Well, again, and we've also got a lot of new people that are in the county. The county has grown since you've been out of office and whatnot. And I'll say it again. I mean, you were very effective as a county executive. I know every year I participate in the Homeless Resource Day at one of the high schools, and I know that was one of the initiatives that you took care of. You're sort of like the Mike Bush of Pasadena.
Don't say that.
Well, if you will, I mean, they've got the Annapolis area. It's Maryland Speaker, our delegate.
Don't put that in.
Yeah, but I mean, Mike does an awful lot.
We're friends
for the Annapolis area.
I know he does,
and certainly you've got your own biases, and you do an awful lot for the Pasadena area and the area that you've served. And this is something that you've served as a delegate.
Correct, 20 years.
And then you've served, obviously, as the county executive. If you could get a pet project through, and there's nothing wrong with that. It's
I had over 2,500 streetlights put in high crime areas. I'm very proud of that. It's something you can't do as a state legislator, but you can do as a county executive.
Right. In your 8 years in office as a county executive, what is your single most proud moment?
Impact fees. That I was able to get the impact fees raised so that the taxpayers wouldn't have to subsidize the new development. I got 2 Democrats and 2 Republicans to vote for that bill. It was a tough battle, but again, bipartisan, 2 Democrats, 2 Republicans, we got it passed. So I think there are many. Homeless Resource Day is one, of course, the Field for Kids with Disabilities. I went to opening day ceremonies last Saturday at Lake Woodford Park. For these kids, and I looked at the kids, and I could see how they enjoyed this opportunity to use that facility. That's a great feeling to know that you can make people happy that way.
When you see people like that, we spoke with the Ripken Foundation, Cal Ripken Senior Foundation, and Steve was saying that just as you did, the executive director, he said, when you see a kid in a wheelchair, or maybe they've got the permanent crutches or the prosthetics or whatever, realizing that they can, go to a field of dreams, into a baseball field, and actually play baseball.
There you go.
Is you've turned somebody's life around there.
Exactly.
What do you hope to accomplish as a delegate in 31B?
Well, there are a number of things that are coming up. One is redistricting. That's going to be a critical issue in the next term. I've tried for years to get an independent commission to draw the lines. The Democrat leadership doesn't want to go with that. But legislative redistricting isn't just an academic exercise in good government. It's also providing an opportunity for compact districts where communities are protected. And also, I support single-member districts. And single-member districts are helpful because it provides direct accountability between a constituent and their elected representative, and it can significantly reduce the cost of campaigning when you only have a small area to run it. Also very concerned about the overdevelopment and the traffic congestion in the area. And I think the state legislature can, with using the carrot, not the stick, but can provide incentives to jurisdictions that want to provide some brakes on the overdevelopment.
Do you think your age is a problem? I mean, you're 75, and I'm not kissing butt here, but I mean, you're a young looking 75.
Thank you, I appreciate that. Well, there's a candidate who was a colleague of mine in the legislature named Ted Sophocles. He's running for re-election. He's 78.
Okay, that was my next question. I mean, I know the average age is 65 in the Maryland legislature. I think it was, and
but there's an old expression: when you rest, you rust.
I've heard something similar. Said if you're not growing, you're dying.
I feel that I still have the passion and the ability to get things done and help people. As long as I feel that way, I'm going to continue to do it.
Assuming you're successful in the primary, and the primary is just a primary, and that's coming up June 26th, I believe.
Early voting is June 14th.
Yep. So and public service announcement: no matter who you're voting for, go out, make sure you vote. Don't ever neglect doing that. That's one of the great rights that we have here in America. Use it. Don't lose it. But you've got, if you get through the primary, you've got a general election in November, and there are 2 Democrats that are running. 2 Democrats, right? You've got Harry Freeman.
Karen Simpson and Harry Freeman.
Right. That you've got to get. Now, this district tends to be, at this point, fairly solidly Republican. Megan Simonaire, who is Senator Simonaire's daughter, came in with, I don't even want to say virtually no experience, with no experience, and she was effective, and she ran as a Republican. So I would venture to guess that it's probably going to stay in the with 2 Republican seats. So how are you polling on against, Brian Chisholm and...
Well, I think the outlook today is favorable, but I always campaign like it's the fourth quarter and I'm 2 touchdowns behind. And I've been campaigning door to door for more than 3 years. I never assume.
That was the rumor we heard.
I never assume anything. I take nobody for granted.
Crazy John Leopold knocking on doors for. That's what we heard several years ago.
So, you don't want to take any single voter for granted.
Right.
And I never have. And I just lay out my qualifications and my accomplishments and my vision and hope people will be supportive.
Had you served out all of your terms in county executive? You said you were considering a run for governor. Mm-hmm. Do you have any future thoughts if you were to win this seat back again? I mean, would you run for governor? I mean,
No, it's highly unlikely that I would do that.
Okay.
No, it's highly unlikely I would do that.
Interesting.
I may have run before.
Right.
Not now.
Chicken Roost, what was your sandwich when you were county executive?
I had, what was it? Was it? Oh, that's right. Thank you, sweetheart. It was chicken noodle soup.
It wasn't even a sandwich.
No, it was see, that's what what's his name?
Ted Levitt?
No, the alderman Cohen. That's what Cohen would probably say was different.
Right? Yeah.
So mine was a soup, not a sandwich.
Okay. And was that consistent when you were a delegate too, or did you not have one?
It stayed up there. I remember I used to go in there and see it up there.
You going to change it when if you win again?
I don't know. I hadn't gotten that far.
I don't know. There might be something kind of fun to put in there.
We'll
see. We'll see.
Well, it's not Chicken Roots anymore, is it?
Yes. Yeah. So Ted Levitt did sell it, but it's same name. And the guy vowed to turn around and keep it the same as what it was.
Does he still have sandwiches and all that?
Yep. Still has the names and everything else. So it's well, I do appreciate the time that you've taken this afternoon. People can get in touch with you. They can email you at jrl@johnleopold.com, and that's Leopold.
And I encourage people to call me at 410-255-4477.
And I will attest that you do answer your phone, and if you don't, you do call them back. You're persistent. If you don't get a hold of people, you will call them back again and again if they want to talk to you. So I do appreciate your time. I do appreciate you presenting the other half of the story. There was a big broadcaster that used to say, and that's the other half of the story. I can't remember.
What was his name?
Edward Murrow, maybe?
No, Harvey? Paul Harvey.
Paul Harvey, yes. And I think the documents, clearly show that, and, I don't want to say that, the scheduler was, lying or out to get you or whatever, but there clearly was a mistake made on the duration of that. Whether that would negate the fact that the crimes that were committed, I don't know. Certainly, I don't think that Bruce Marcus represented you as well as he could have. I wish you all the luck in the campaign. I do. I've got my own thoughts as to whether I think you'll win that race or not, and I'll hold off on those until we get a little bit closer. But check out all the candidates. You can find out more about John Leopold at johnleopold.com. He is running in District 31B, which is up in the Pasadena area. You get a little slice of Severna Park, I think, don't you?
Tiny slice of Severna Park, a slice of Shipley's Choice.
Okay.
A slice of Fox Chase.
A little bit of Glen Burnie?
A little bit of Glen Burnie.
Thank you very much. I appreciate your time, and good luck.
Thank you very much.
Well, there you go. Do you think he got screwed or not? Thoughts? Comments? Shoot us an email at info@themarylandcrabs.com. Of course, you can visit our website at themarylandcrabs.com. You can leave a comment on our Facebook page or group, which would be the Maryland Crabs Podcast. Our Twitter account is at MD Crabs Podcast. And if you get over to Apple Podcast or Google Play or any of those places where you get your podcast, make sure you give us a rating. And if you've got a few minutes, give us a review. They really do help. And tell all your friends about us. Coming up next week, we have a discussion with Margaret Davis, who is the relatively new executive director for Maryland Hall, and the new vision of Maryland Hall, the expansion of Maryland Hall, and all the cool things that are going on. And you will definitely want to tune into that next Thursday. And between now and about a month from now, we will have a whole lot of election crab cakes. We've selected several different key races throughout the area, and we have invited all of the candidates to come on and talk for about 10 minutes about their race and why you should vote for them. And finally, if you missed the episode last week where Tim and Naptown Pint Liz Murphy got bombed at 1747, give that a check out. That was a really good one. That's about it for this week. This is John Frenay for the Maryland Crabs Podcast. We will see you next Thursday.
This has been the Maryland Crabs Podcast with Tim Hamilton and John Frenay. Sure to follow them in all the regular places, Facebook, Twitter, YouTube, and online at themarylandcrabs.com. Take a moment to rate us on iTunes. Now, get the hell out of my kitchen. Seriously, go!
You're still here? It's over. Go home. Go.